SJC-12389, Doroteo Polanco v. Andres Sandor and others.
Mr. Sheehan. Good afternoon.
Good afternoon, Mr. Chief Justice, Justices. May it please the Court, I am Rick Sheehan. I represent Mr. Polanco in this matter. I am the designated appellant, and I stress the designated in that this case was certified to the appeals court, and it's percolated up to this court, primarily because there's a lot of inconsistency throughout the Commonwealth, excuse me, as to how the superior courts are applying or interpreting 231.
Fran?
Yeah.
Sorry, go ahead.
Okay. And I also state that I filed leave with this court to file a motion for a non-conforming brief, which I did file, and you'll note that it's a very thin brief. And the reason for that is it's a very discrete issue, and it's not dependent on a case record or specific facts of this case. It's simply how are we to interpret what the legislature meant by the plaintiff shall post a bond in the amount of $6,000 or its equivalent is the operative language. The legislature chose to put or its equivalent in that sentence, enacted into law, because they contemplated other means of satisfying the requirement other than cash. If otherwise, they would have simply punctuated at the end at cash, $6,000 cash. They did not do that, so clearly they looked for alternatives to cash. In this case, we posted a surety bond. The net effect is that if there was a imposition of costs, the prevailing party, in this case the medical community, would get $6,000 by the bond. $6,000, not to be cavalier again, I use that word, but $6,000 is $6,000. There is no undue burden on the defendant in collecting it.
But there is, I mean, if you were to get money from a surety bond.
Excuse me?
If you have $6,000 in cash, and there is, and the medical malpractice case is tried, and there are, say, $10,000 in costs, if the clerk has the $6,000, the clerk hands the $6,000 over to the defendant. If it's a surety bond, what must the defendant do to get that money?
I don't believe they don't need to access the courts. If the call for the plaintiff to pay the $6,000, in the first instance, the surety company will seek the money from the bondholder. If they don't produce the $6,000, they will then pay it, and they do that in a very timely manner. And it does not require access to the court or further hearing. So the surety company would then have to go to the plaintiff to get the money, but in this instance, the defendant will have already been paid. So they will get the $6,000 in a very timely manner, and I think that satisfies and covers the intents and purposes of the legislature. The legislature did not make this punitive, and it's not to deny access. In this instance, it may happen in others that we were late on getting our offer of proof to the tribunal. I produced it the day of. It was considered untimely, so therefore we didn't have the evidence, and we were required to post the bond. If we had to come up with $6,000 cash, my client could not have done it, and therefore we would have been denied access to pursue the case. We do that at our peril. It is our responsibility to pay the $6,000 back to the surety company. It has no net effect on a prevailing plaintiff. So
Bond serves two purposes, though. I mean, one of the reasons that we have the statute is, I'm not commenting at all about this case or any particular case, but one of the reasons that we have this is to discourage frivolous medical malpractice lawsuits. That's one of the reasons that the statute passed. And if it's a $6,000 surety bond, what's that cost? $600? Then you don't have that same disincentive. I think that's the theory behind it.
well, no, it is, well, perhaps it's a gradation different, maybe in weight, but first of all, I would suggest that the posting of the bond, whatever that cost is almost akin to a collateral source. The $6,000 would go to the prevailing party. As to the deterrent effect, it is at our peril. And in this instance, we were late. We were procedurally late, and the only cure was to either post a bond or come up with $6,000. So I think if people willy-nilly just said, I don't care what the tribunal said, that would be a problem, but that's not what's going on here. In this specific case, we were late, and we want to pursue our case.
Is my memory of the Superior Court practice is not that long ago. In other circumstances, if somebody just cannot afford to access the ability to have the matter adjudicated because they don't have the means, you can file a motion to have the security bond waived. Right?
Correct. In this instance, I thought we would have to exhaust the ability to get a bond first. And the reason for that is Middlesex had routinely accepted these bonds, as long as they know. I asked the clerk about that. They had never refused one. Other jurisdictions have now decided that cash means cash and not its equivalent. In Mr. Sandor's brief, or Dr. Sandor's brief, my sister quoted that bear with me 1 second. Cash or its equivalent means a readily negotiable instrument, which I suggest a surety bond is, or certified check of money order cash, or securities. Securities which are subject to market fluctuations, puts the clerk in a situation where they have to monitor market value. I mean, if you post stock securities and they go up and down, there's a possibility that it would not satisfy the $6,000 requirement. Here, $6,000 in surety clearly satisfies the $6,000. My sister also made an analogy to the criminal case where a judge would post or bail at, say, $6,000 cash or surety, or $6,000 cash only. I understand the difference, and I think the elements are clearly different. Here we're talking about access to the courts. In that context, we're talking about public safety or other elements that are taken into consideration in a criminal bail order. So I would suggest that by all means, a $6,000 surety bond satisfies the intent of the legislature. And as to a deterrent effect, clearly it's at our peril that we go forward. There is a deterrent. It's not something you do lightly. If you lose, you have to come up with the $6,000. In this case, we certainly are hoping to prevail. But in the instance that we don't, in that eventuality, we're still going to be saddled with that burden of $6,000. So we don't elude the deterrent effect, but we do take advantage of the fact that we can get a bond to satisfy $6,000. which is exactly what we did. And again, well, Your Honors are well aware that different courts have done different things with this, but I would simply suggest that $6,000 to defray the cost is what the legislature intended, and that is exactly what a surety bond does in this instance.
All right, thank you. Ms. Hammerstedt?
Good afternoon, Chief Justice, Associate Justices. May it please the Court, Allison Hammerstedt on behalf of the appellee, Andres Sandor, MD. What's before you today is a reported question up from the Superior Court of Middlesex County as to whether a surety bond paid at a fraction of the cost of the statutory requirement satisfies the plaintiff appellant's burden pursuant to Section 60B of MGL Chapter 231. The question before you, Your Honors, is really one of legislative intent, and specifically what is meant by cash or the equivalent. Pursuant to the Section 60B, the key language indicates that in the event that a defendant is successful at a tribunal, the plaintiff is required to post a $6,000 cash bond, well, a bond of $6,000 secured by cash or the equivalent. The lower courts, the superior courts, have interpreted the purpose of this statute is to discourage frivolous claims, as Chief Justice did raise, but also, which is stated within the actual statute, to defray the cost of the defense. And also, which has been raised by the lower courts, is to possibly eliminate unnecessary claims, which would mean in the event that, for example, a plaintiff did not file an offer of proof, as is the case here, the plaintiff may consider, well, this might not be worth pursuing, which would also save time and expense for the other party, as well as the court and other parties involved.
So what do you say or its equivalent means?
So that specific language, it's, again, not addressed in the language of the statute, but we can look to other case law and interpretations. That language was specifically raised in Commonwealth v. Ray, which, as my brother raised, was an interpretation of a criminal statute in terms of bail bonds versus surety bonds. The court there identified that equivalent can mean two things. It can mean in effect, or it can mean in value. The court determined that a surety bond in the Ray case, in order to have teeth, which is what the appellee is arguing with 60B here, would need to be 10 times the requirement of the cash value in order to compel the defendant to appear at court. Here, we'd like to distinguish that case somewhat to maintain that we want 60B to run for the proposition that the equivalent needs to be in value. So there needs to be some collateral attached. In this particular case, Your Honor, the record indicates that the surety bond paid by the plaintiff was only $120, and that's 2% of the $6,000 cash bond requirement as stated in 60B. That's not sufficient to meet the purpose of the statute, which I've already stated.
But from your client's perspective, it's $6,000, right? Because your client's going to get the $6,000 if anyway, right? It's how he got someone to pony up the $6,000. Does it matter from your client's perspective?
It certainly does, Your Honor.
Why?
Well, once we get, so the $6,000 ultimately, as the statute indicates, is paid to the defendant in the event the plaintiff is not successful in final judgment. However, when we have a surety bond, I would represent to the court, I have spoken to the surety bond company in this case, and they've indicated to me that in the event that judgment does enter, the court or the victorious party, which would be the defendant, needs to send a notice of the judgment to the surety company, and then the surety company, what they do then is evaluate a claim, and they make a decision. Are we going to pay the $6,000 or are we not? So what that does for the defendant in that case, it puts them at an incredible prejudice in the event that the surety company decides they don't want to pay the bond requirement, because at that point, the additional burden shifts back to the defendant, which is, again, contravenes the whole purpose of the statute. And at that point, I would have to file a third-party action against that surety company to enforce the bond.
So you have an enforceable judgment against, you know, the malpractice plaintiff here, and there's a surety company that's put a bond into place. What defenses could they come up with? I understand this theoretical matter, but I'm just trying to
Sure.
understand, that's what bonds are for, right?
I agree, it doesn't have a lot of legs to run on there, Your Honor. However, I don't think that matters for our analysis here, because at that point, the burden still is on the defendant to expend more time and expenses by the defendant to enforce that bond. That's not a burden that would be on the plaintiff here. The plaintiff's already shifted the burden over to a third party. Again, this all runs in contravention.
How do we know this from the record? Because what the plaintiff says is, well, if we lose, they pay, and then they sue us. You're saying to us, if they lose, they may not pay, and I have to sue them. Now I have to expend money above and beyond $6,000. So
Right.
what does the record say?
Well, Your Honor, again, this is a
There's
matter
none.
of first impression, unfortunately, so I don't have a lot.
But yeah, it could be first impression legally, but there should be some facts, shouldn't there?
I agree, Your Honor, and that's why I did try to do my due diligence in contacting the surety company and determining what would happen, because I personally have not had this experience in going after a bond at final judgment, and based on my research, have not encountered a case where that's happened.
What does this do as far as a deterrent value in filing a lawsuit where perhaps a plaintiff doesn't want to spend the money for an expert letter to satisfy the tribunal? Can they just go forward and then post the $120?
I think that's, again, it completely takes out the teeth of 60B, Your Honor. If they decide they don't want to expend the good faith effort and money to pay for an expert to establish that they have a meritorious claim at the outset, then they should not, without filing that motion for indignancy, they shouldn't just be able to electively file 2% of the bond requirement as stated in 60B. I'd also like to point out, just in terms of that, the motion for indignancy, which is a provision of the 60B statute, the court in Commonwealth v. Ray, the dissenting opinion, did raise that as a policy consideration, that with this elevated surety bond requirement, the 10 times amount, that doesn't take into consideration potential plaintiffs that are not able to afford that bond requirement. But here, I think what allows this provision for the actual cash or the collateral, which was also outlined in Eveline v. El Jaziri, which Judge Kerpelani addressed in his order, it does allow the plaintiff another avenue to file that motion to reduce the bond requirement if they are not able to pay, which again, I believe it further supports the obligation to post cash or collateral rather than the surety.
Okay, thank you.
Thank you very much.